Hello and welcome to Legal Links. This is a legal information program brought to you by the Oregon State Bar. My name is Steve Todd. I'm a pro tem circuit court judge serving Multnomah County, and I'm a member of the Oregon State Bar. Today we'll be discussing DUIs in Oregon. With us today are Kate Wallum and Mike Schmidt. Kate has been a public defender since 1982. She's the current president of the Oregon Criminal Defense Lawyers Association. She's tried over 2,000 cases in front of juries and just about the same number of cases before the court. Mike is a deputy district attorney with the Multnomah County District Attorney's Office. He's assigned to the DUII intake desk at the Justice Center. He screens all Multnomah County misdemeanor traffic cases, including DUIs. I can tell our audience I've seen both these lawyers in action in court. They know what they're talking about. We're sure glad to have you here. Welcome.
Thank you.
Well, first of all, we should talk about what really does DUII stand for? What does that mean?
It's driving under the influence of an intoxicant. It doesn't mean drunk driving. You can be guilty of driving under the influence of an intoxicant if you're a long ways from falling down, sloppy, throw up on your shoes drunk. It means that if you shouldn't be on the road because you're not quite so fast as you would be if you had all of your mental and physical faculties, you're guilty of driving under the influence.
Well, we used to, the old days, called it drunk driving, but Mike, you don't have to prove that in court, do you?
No, that's right. Like Kate was saying, you don't have to be falling down, vomiting on yourself drunk. There's two ways in Oregon that you can prove driving under the influence of intoxicants. Either by testing the blood alcohol content with a .08 or greater at the time of driving or operating a vehicle would be one way. The other way would be to prove that you were intoxicated to a noticeable and perceptible degree, either by alcohol or other intoxicants in the blood.
Now, in the old days, they'd even talk about DUIL, liquor, instead of intoxicant. So what's the difference? What's an intoxicant?
An intoxicant can be almost anything that changes you. Some of them are legal and some of them are not. For example, if I have a Benadryl, I might be a little woozy and I probably shouldn't drive. But it is not a controlled substance. It's not an inhalant. And it's certainly not alcohol, so I wouldn't be guilty of driving under the influence of an intoxicant. I might have some difficulty with reckless driving, but it wouldn't be a driving under the influence charge. If, on the other hand, I was taking Tylenol with codeine.
So it's a prescription drug.
Right, and it can affect people by making them a little woozy, making them a little slower than they should be. They shouldn't drive afterwards. I know if you go to the dentist and they give you something like Vicodin or something after they've pulled a tooth, they'll tell you you have to have a ride home. And there's a good reason for that. It's not legal and it's certainly not safe.
Now, Mike, does the prosecution have to prove the person realizes that they're under the influence?
No, unlike most criminal crimes, driving under the influence of intoxicants is what they call a strict liability crime. You don't have to know that you're doing it. You just have to be in the act of doing it. So the state doesn't have to prove you meant to drive. It's not a defense to say, well, I didn't mean it. We don't have to prove that you knew what you were doing or you should have known better. Just the fact that you were driving and under the influence either to the .08 or to a noticeable and perceptible degree makes you criminally liable.
There are two really good reasons for that, and the first one is that if you've been drinking, you're probably not a good judge of whether or not you should be driving and whether or not you're under the influence. And the other is that sometimes well, I had a client once who is sure that her drink was dosed at a bar, but she still shouldn't have been driving. The fact that she didn't get under the influence on purpose doesn't change that she wasn't supposed to be behind the wheel.
Well, what happens from the very beginning? The police see a car driving down the road, it's doing some unusual things, they decide to pull the car over. How does that happen in the real world?
Well, they turn on their lights.
Well, we know that.
And sometimes a siren.
All right, so the police are pulling the car over, and what's the first thing the driver would expect at that point?
That they're told to stay in the car, produce a driver's license, registration, and a valid insurance card. And the police officer is going to want you to roll down your window because he's going to want to be able to smell whether or not you have been drinking. If your driving has been a little bit unusual, he's going to look at your eyes to see if they are clear or if they're bloodshot or watery or worse, both. He's going to look at your skin to see if your face is pale or if it's flushed. He's going to look at the pupils of your eyes to see if they are very, very small as if you had been taking a controlled substance, or very, very large, as if you had been taking yet another controlled substance. And he's going to listen to your speech to see if it's slurred or if it's thick, if it doesn't sound like it's normal.
Well, Mike, there's an eye test people talk about in court called nystagmus. Can you explain what that is?
Sure. What we talk about with a field sobriety test is testing for horizontal gaze nystagmus. Nystagmus is kind of a fancy word for jerking of the eye. What the officers are trying to detect with a horizontal gaze nystagmus test is three different things. They're looking for three clues in each eye. One is if your eyes can follow a stimulus smoothly, and they'll look for that in each eye. The other is if at the maximum deviation, or the farthest you can possibly look out of your eye, if at the resting spot, is your eye jerking or is it just able to rest calmly? And then the third way is at 45 degrees, if you're looking at a stimulus, is your eye jerking before the officer even gets out to 45 degrees? So there's 6 total clues, 3 for each eye. But nystagmus is a fancy word in layman's terms, just more for jerking and what that tells them about whether or not you might be impaired.
Well, field sobriety tests can be all kinds of things. I remember in the old days they had people touch their fingers or count or do the alphabet or whatever. But isn't really the purpose is just a screening tool to see if the person should be taken in for more testing?
Yes, although they use the field sobriety tests to make the initial decision whether or not to arrest, sometimes that's all they ever end up with. And then the field sobriety tests and the driving are what they're going to try to go forward with at the time of trial.
So just if I could just jump in there, the field sobriety tests also by nature are designed to be divided attention tests. What they're trying to determine is whether or not you can safely operate a vehicle or if you're impaired. Driving a vehicle is, obviously we all know, it takes many different things going on at once. You're looking at traffic, signs, signals. You have to control the accelerator, shift if you have not an automatic car, steer, all those things. So these tests are specifically designed to divide your attention. They'll be talking to you while you're taking these tests. They'll be instructing you to do certain things but not start moving yet. And all of those are clues of whether or not you can divide your attention, which would tell them whether or not you could safely divide your attention while operating a vehicle.
Yeah, they want to know if you can walk and chew gum.
Exactly.
Well, I guess maybe one reason to see if there's some other reason that you're not driving well. Being sleepy or tired or
Sick,
distracted. Well, what kinds of tests can they force you to do, and what kinds of things can they only ask you to do?
Can't force you to do anything. They can make you pay for it if you don't.
And how would that happen?
Well, they can ask you to take field sobriety tests, and if you say no, then they get to tell the jury and the judge at the time of trial that they offered you the chance to prove that you could pass field sobriety tests, and you said no. And then the prosecutor gets to argue to the jury, you know, they knew they weren't going to pass. The defendant was only too well aware that he was under the influence, and so he refused the field sobriety tests. That's a powerful instruction to give the jury. The same thing is true of the taking a urine test or taking a breath test. Again, the prosecutor gets to argue to the jury that you wouldn't have refused it if you thought you were going to pass. In the case of the urine and the breath, they also get a driver's license suspension that is much longer than if you do take the urine test or you do take the breath test. And you can get a hardship license immediately if you take the urine test and the breath test and you fail. But if you refuse them, you can't get a hardship license for quite a while longer, depending on whether or not you've done this before.
Let's say the person refuses to even get out of the car. What would happen in that situation?
I've seen a few situations like this. The officer has to make a judgment call at that point. Do I feel that I have enough information collected from things that Kate was talking about earlier, odor, looking at the eyes, slurred speech, things like of that nature? Do I feel that I have enough evidence at this point, probable cause they call it, to make a determination that you're probably driving under the influence of intoxicants? And at that point they will remove you from the car if you don't help remove yourself.
Do they have to see you driving to make you take these tests?
No, but they have to have good reason to believe that you had been driving. I've had lots of cases where the police officer said he drove past, for example, the Safeway store parking lot at 2 in the morning, and then there was nobody there, and he was doing his regular route, and he came by 15 minutes later, and there was somebody there, and they were passed out in the front seat of the car. He's got pretty good reason to believe that that guy drove to get there. Now, maybe he didn't. Maybe somebody drove him and dumped him there. But the officer still has pretty good reason to believe that he drove himself there.
And a lawyer would call that circumstantial evidence then?
Yes.
Okay.
Anything that's not eyewitnessed is circumstantial evidence. My favorite example of circumstantial evidence is a fingerprint. Now, you don't think of that as minor evidence. Fingerprints are pretty good evidence the guy was there, but nobody saw him.
That's a good example. Can they wait outside taverns or put up roadblocks or anything like that?
Well, as far as roadblocks go, there's constitutional issues in Oregon that have said that actually stopping people without any sort of cause, just every single person, violates constitutional rights in Oregon, although not the United States Constitution. So that's not going to happen. But, you know, staking out a tavern, something like that, is a lot not unlike officers who are waiting down the freeway and monitoring speeding. They can do this. They can set up where they can monitor the flow of traffic and watch for irregularities and see if traffic laws are being broken. So, yeah, they could park somewhere and watch a bar, watch people leave a bar, things of that nature, and monitor the flow of traffic.
Do they have to see something that involves your driving behavior, or can they just pull you over for bad tags and then look at a DUII situation?
That happens more often than you would believe. There is something very unlucky about guys with bad tags. They all get pulled over. They've all been drinking. It's amazing. Bad tags, license plate light out, any equipment failure, not wearing your seatbelt, any number of things they can pull you over for. And then they find out other things after they've pulled you over. They smell that odor. They see the fumbling fingers as you're trying to reach for your driver's license and your registration. And one thing just leads to another.
We'll say one thing does lead to another. Officer decides that you really should be taken in. How does that work? What happens?
Well, he has you get out of the car. If you've not done field sobriety tests yet, he offers you the opportunity to do those. And today we have a number of cars with video cameras, so they can actually get good pictures of the field sobriety tests being done out there on the street. If he arrests you for driving under the influence, he will read you your rights, handcuff you with your hands cuffed behind your back, put you in the back seat of a patrol car, and call to have your car towed. Your car will be towed and stored in a tow lot, and you'll be taken downtown. They will book you into jail. They take your fingerprints. They take a mug shot, and you sit there in jail until a recog officer comes around and interviews you, and maybe you get out and maybe you don't.
Now, Mike, who gets out and who doesn't? Is there any rule behind that?
Well, you know, recently, at least for the Portland Police Bureau, they've gone to a book and keep policy on everybody. So unless they apply for an exception from their sergeant, everybody's going to get book and kept until a recog officer can come and interview you. Things that the recog officer would be looking for would be, is this your first offense ever? Do you have any other criminal things or failure to appears at court? Do you have a history of not showing up for court dates? They'll take that into consideration. How grievous was this particular incident? Were you just pulled over because you were swerving in your lane, or did you crash into somebody? And maybe that makes a difference, maybe it doesn't. But they're going to take all of those circumstances into consideration and decide whether or not you should be released.
Well, let's say that they find you passed out in the car and they can't say for sure that you drove there. I've heard that oftentimes they'll take people to detox. Can you tell our audience what that means?
It's a place to go where they do an independent assessment of you as you walk in the door to decide whether or not you're under the influence of alcohol or drugs and unable to safely care for yourself. If they think you are unable to safely care for yourself, they will hold you for a minimum of 4 hours, checking on you every little bit until you are sober enough to be released to the public and be able to take care of yourself. They don't want you walking out into traffic on the freeway and getting run over.
But they don't have to charge you with a crime to do that, right?
No, they don't. They just have to find that you are unable to safely care for yourself.
Well, let's say you're at the police station. They've decided that they're going to arrest you. What happens next? Is it the breath test?
What actually happens next is they run your record to find out how long your suspension is going to be if you fail or refuse the breath test, and how many prior DUIs you have, so that they know whether this is a misdemeanor DUI or a felony DUI. And if it's a felony DUI, you are almost certainly not getting out, because that means you've been convicted of driving under the influence at least 3 times in the prior 10 years. So at that point, they think you're a menace, and they're going to hold on to you. They then take you into a little room where the breath testing machine is, and they offer you a breath test. If you fail the breath test, you're done. You're going off to jail. If you pass the breath test, then they have to decide whether they think there's something else on board, one of the intoxicants we were talking about.
In other words, maybe you're taking some drugs and that's why you're impaired.
Maybe there's a mix. Or maybe you blew a .00 and there's no alcohol in your system, and maybe it's all something else. They have to make a decision about why they're seeing what they're seeing. Are you an unusual person? Maybe you have really bad balance. Maybe you've had a head injury in the past, and it produces some symptoms that might mimic under the influence. Maybe you're a diabetic and you're in trouble, and it produces some symptoms that mimic being under the influence. So they have to decide whether they're looking at something that is caused by an intoxicant or caused by something else. And if it's caused by something else, maybe they have to have medical come down. Maybe they have to take you to a hospital. If you fail the breath test, then they have to offer you the possibility of a blood test if you ask, and you have to pay for it. But they have to give you the opportunity, so they will take you to, if you ask for a blood test, they will take you to a hospital that will draw your blood and store it for evidence purposes for later.
Now, Mike, sometimes the police actually get a search warrant to get a blood test. Is that right?
Yeah, that's right. Especially in circumstances where traffic accidents, serious traffic accidents, either a fatality crash or serious injury crashes, that often you see warrants for blood draws. And they'll do several over a course of hours to determine how your blood alcohol content is going over that period of time. But even for misdemeanor DUII cases, sometimes we see them applying for warrants where there are refusals. Field sobriety test refusals, and then a breath test refusal, and the officer looks at the evidence they have, and they certainly feel that they have probable cause, otherwise they wouldn't even contemplate applying for a warrant. But they might think, well, you know, if this all goes in front of a jury or a trial, this might not be the most solid case, so they really want to make sure that they have enough evidence. Typically that won't happen if it's your first DUI and you're diversion eligible. But second, third DUI, I think they're taking a much harder look. And actually right now it's becoming more easy, and the police are becoming more proficient at applying for warrants with electronic warrants. It's a faster process than it used to be, so it's happening more frequently.
Okay, let's say the driver doesn't believe the result. Years ago we called it a breathalyzer, now it's the intoxilizer, but whatever you want to call it, if they don't believe the intoxilizer result is accurate, what can they do?
They get that blood test. They can ask the police officer for an independent blood test. They're taken to the emergency room closest to them, and at their own expense they can have the blood drawn, if the emergency room people have time to do it.
Well, let's say they're going to get suspended, either that they failed the test or they refused the test, and they don't like the suspension going into effect. Can they challenge that part of it?
Yes, they can. They have a hearing. They have to challenge it by sending a notice in within 10 days. They send the notice in, and they have a hearing within 30 days. It's in Beaverton for the Portland area. The police officer comes and presents his evidence about the refusal or the failure that resulted in the suspension, and you get to present your evidence.
Okay, well, let's go on beyond that. The person's been through the process, and now they got a court date coming up. What happens at their court date?
Well, at the first court date, what you'll see is it's called arraignment, typically. Generally, people will fill out, at the misdemeanor level anyway, you probably will be out of custody. So you're going to need to determine whether or not you want to hire your own attorney, or if you are eligible for a court-appointed attorney. So you'll fill out paperwork for a judge to determine whether or not you are eligible. There will be an attorney in the courtroom present, usually from one of the public defending agencies in town. They take turns covering the arraignment courts.
That was me this morning.
And they're there to protect your rights, make sure you don't say something like, "Oh, Judge, I definitely did it, I'm so sorry." You know, they want you to be there to just either protect your rights, get you an attorney if you need one, or help you find an attorney if you're not eligible for court-appointed attorney, and then you're arraigned. Well,
if you're eligible for diversion, do you have to decide right then and there, or do you get some time to talk to a lawyer?
You get time, about 30 days to talk to a lawyer. Most of my people choose diversion or not based on the driver's license. If you go to diversion, it's not as good as being found not guilty. It's not as bad as being found guilty. You don't have to go to jail if you go to diversion, but you do have to do exactly the same alcohol treatment program. It costs the same amount of money. You don't lose your driver's license. And at the end of the diversion period, the DUII is dismissed. So if anybody asks you if you've been convicted of a crime based on this incident, you can honestly say, no, you haven't been. That's the good news. The bad news is that it stays on your record forever and ever, amen. And you can't go to diversion again for another 15 years. The law just recently changed. It used to be 10. But it's now 15 years, and during that 15-year period, you cannot have been convicted of any of the traffic crimes, reckless driving, hit and run, drunk driving, of course, or you will also be ineligible for diversion. And the other bad news is that every insurance company knows that when they look at your traffic record, DIVR means you got a drunk driving ticket and you went to a program and got it dismissed.
So they can still increase your rates even if you don't get convicted?
Oh, they sure can.
Well, are there some reasons people don't qualify for diversion? Mike, I know there's been talk about truck drivers. Tell us about that.
Yeah, that's right. If you have a commercial driver's license, you're not by statute eligible for diversion, no matter how close to a .08 or not that you were. You're just not eligible. Assaults, if there was an assault committed during, or if the district attorney charges you with an assault.
You mean somebody was hurt in a car crash?
Someone was hurt in the car crash, exactly. Then you're not eligible. If there was injury, for instance, I had someone came in to try to get into diversion. He was driving. He was found to be he took a breath test and he blew a .12 or something over the limit, to be certain. But all the witnesses on the scene said that he wasn't at fault whatsoever for the accident. The officers didn't charge him with reckless driving, but there was a major injury. It was actually a fatality accident. The other driver was at fault. But because of that injury, he still wasn't eligible for diversion. So there are some things that will keep you out of diversion. Failing to appear at your arraignment, at your initial court date, is a reason the state can object to you getting into diversion. The judge will have to make a determination there whether or not you have good cause to still get in.
Okay, when I do diversion court, a lot of people just want to represent themselves. They say, well, what's the big deal? Why do I need a lawyer? Why should somebody get a lawyer if they want to go to diversion?
Because you can only go once in 15 years. Everybody thinks they're never going to get another DUI ticket, but everybody thought they weren't going to get the first one. Nobody thinks that when they get into the car they're going to be arrested. There are all kinds of things a lawyer can do for you. They can examine the evidence and make sure that the evidence is sufficient for conviction. They can look at whether or not the evidence was gathered improperly. They can look at whether or not you have any defenses. If you were as good at figuring out the defenses as I was, you would have gone to law school for 3 years and been practicing law for this many years. A lawyer can do an enormous number of things for you in analyzing your case and deciding whether or not diversion is a good option for you.
I've seen some cases where they actually pay the lawyer to help them go through the paperwork so at least they know what to expect even if they do represent themselves.
Absolutely.
What's a good way to find a lawyer?
Lawyer referral service.
That's the Oregon State Bar number where you just call and they give you names of lawyers, and I understand it doesn't cost very much. It's a good way to start.
Modest means. The Oregon State Bar has a modest means program so that if you are relatively low income but probably don't qualify for court-appointed counsel, they find somebody for you that specializes in that area but won't take your house and your firstborn child.
Well, if you don't qualify for diversion, what happens? You end up going to trial then?
Yes. DUIs are not plea bargained in the state of Oregon. Since the mid-'80s, you cannot get a DUI dismissed or reduced to another charge, such as careless driving. Once you are charged with driving under the influence, you're going to go to diversion, you're going to go to trial, or the state is going to be unable to proceed for some reason and get it dismissed. But it will not be plea bargained.
Are there any special defenses or issues people should be aware of?
Well, we talked about some of them. There are things that mimic being under the influence, such as being diabetic, having a head injury. I've had clients, I had a client who broke up with his girlfriend that day, and so his speech was a little bit thick because he'd been crying. His face was flushed. He'd been crying. His eyes were watery and bloodshot. He'd been crying. He hadn't had anything to drink, so there was no odor. The officer simply thought he'd been drinking something without much odor, such as vodka. But when he actually got into the police station and blew into the machine, he blew a 00, so then they thought it was drugs. But yeah, there are lots of defenses.
But that's a good reason to get some legal advice.
Absolutely.
Well, I wish we could keep going, but that's just all the time we have for today. It's been a great show. Thank you so much, Kate and Mike. Really appreciate the time you've taken out of your busy schedules to help us provide information about DUIs to the public. Many valuable resources were discussed today, and if our audience didn't have a chance to write them all down during this program, we hope you'll visit the Oregon State Bar's website. We've got listings there with phone numbers, additional websites. That's all at www.oregonstatebar.org. You can also visit the Oregon State Bar's website to comment in this program, watch these programs, and give suggestions for future programs. We hope you found this program helpful and informative, and on behalf of the Oregon State Bar, I'd like to thank you for joining us. We hope to see you again soon on Legal Links.